Criminal Justice Section's mental health standards, which were approved by the ABA House of Delegates in 2016, and was the reporter for the ABA resolution on mental disability and the death penalty endorsed in 2006. He's published works on mental health in books published by Harvard University Press, Oxford University Press, and the law reviews of the University of Chicago, Northwestern University, the University of Pennsylvania, and the University of Virginia, among many others. You've already met Ken Melson. By way of background, Ken is a professorial lecturer in law at George Washington University. He is a past president of the American Academy of Forensic Sciences and is designated a distinguished fellow. He was the chair of the American Academy of Forensic Sciences Ethics Committee and serves on the editorial board of the Journal of Forensic Sciences. He's also a past chair of the Council of Scientific Society Presidents and served as co-chair of the Subcommittee on Forensic Science, Committee on Science of the National Science and Technology Council within the Executive Office of the President from 2009 to 2012. Ken also served as Senior Advisor on Forensic Science in the Office of Legal Policy at the United States Department of Justice from August of 2011 to September of 2012. And for over 15 years, he has represented the Department of Justice as a board member of the American Society of Crime Laboratory Directors Accreditation Board. And for over 45 years, he's taught law and forensic science courses at both the law school and the Department of Forensic Science at George Washington University. Please welcome the panel.
Thank you, Matt, for those introductions. I'm going to be very brief because I want to give as much time as we can to our panelists. The discussion on mental health today is going to be on competency to stand trial. Mental health issues are often very complex and disturbing for all parties involved in prosecution and the litigation surrounding that prosecution, including families of the victims and families of the defendant. So we want to discuss competency today, and we're going to have a two-part panel. We're going for an hour and then have a break and then go for another hour after that. These two gentlemen have worked together quite a bit, and they have a wonderful program set up for us. Now, I also wanted to mention, I understand that you all received an email yesterday concerning all the bios of the panelists that will be up here today, as well as a description of what the panel is going to be covering. So if you have that, hopefully you've read it. Otherwise, there's a brief description of the panel in the brochure that you all have. So without further ado, I'd like to turn it over to Chris Slobogin. Who's going to go first?
Yep,
is that correct? Thank you.
Great, thanks. Terrific to be here in this beautiful building. I come from Vanderbilt, and I have facility envy. This is a beautiful building. We couldn't afford something like this at Vandy. As was just mentioned, we're going to be talking about what used to be called competency to stand trial. Nowadays, it's usually called competence to proceed. And the reason for that is, as all of you know, 95 to 98% of all criminal cases don't go to trial. Rather, defendants plead guilty. So what we're really talking about is competence to proceed with the criminal process, whatever happens during that process, whether it's pleading guilty, going to trial, having charges dismissed. So I'll use the phrase competency to stand trial from time to time, but I'm probably going to, generally speaking, use competency to proceed in describing what the topic is today and talking about the topic today. So I'm really curious, how many of you are lawyers? I had the impression all of you would be lawyers, but apparently not so. So how many are non-lawyer scientists? Oh, interesting. Okay, how many of you are psychiatrists or psychologists? Oh, good. So we can say anything we want then, and you won't know any different, right? So I will be talking mostly about the legal perspective on competence to proceed. And Eric will be talking mostly about the clinical perspective and empirical perspective. But I like to pretend sometimes that I'm a mental health professional, so every once in a while I throw in diagnostic terms just to impress people. Eric, of course, is very well versed in the law, so both of us will be talking about both legal and clinical issues. Here is a brief summary of our bios. The only thing I want to emphasize, since we've already been introduced, is the third bullet point under me, Chair of the American Bar Association Criminal Justice Section Mental Health Standards Task Force. Matt mentioned this. We were charged back, I think, in 2012 to look at the ABA's criminal justice mental health standards, which have been in existence since the 1980s, and were over 400 pages long, about 100 pages of black letter and 300 and some pages of commentary. We, as a task force, were charged to look over those standards and that commentary and revise it if necessary. And of course, we thought significant revision was necessary because those standards came into being in the 1980s. And this was 35 years later when we were asked to review it again. So we made several changes. As Matt mentioned, the revisions were adopted by the American Bar Association in 2016 as Chapter 7 of the Criminal Justice Standards. And if you don't know what the standards are, they are standards produced by the Criminal Justice Section of the ABA in a number of different areas, having to do with the defense attorney function, the prosecution function, the right to jury trial, and so on. We did the standards on mental health, criminal justice mental health, and once again, over 110 pages of black letter standards, and the commentary is not quite finished yet, but probably will be about 500 pages long when it's all said and done. So it's a mammoth undertaking. The first undertaking actually was produced by 6 different task forces, which is incredibly unusual within the ABA. Usually there's only one task force. This was 6 different task forces composed of mental health professionals and attorneys and judges. Our task force was a loner, but of course we were only charged with revising the standards and not coming up with them from a blank slate. In any event, I'm trying to emphasize a lot of work went into this, and I will be referring to those standards over and over again in what I have to say today. You'll notice in parentheses very often numbers such as you see there at the top of the page, 4.1. That refers to Chapter 7, Section 4.1 of the American Bar Association Criminal Justice Standards. And if you're a masochist and want to look them up, feel free. They are online, and I actually urge you to look at them because they have a lot to say about mental health issues. So what are we going to be doing more specifically? Well, this is a very brief description of what we're going to try to accomplish today. It doesn't cover everything we're going to talk about today, but basically we're going to be trying to acquaint you with the issues associated with competence to proceed evaluations and the role attorneys play in competence to proceed evaluations and in adjudications of competence. We're also going to be looking at what happens after a person is found incompetent to proceed. They're usually sent to a hospital, sometimes instead required to undergo outpatient treatment. So we're going to be talking about the restoration process as well. And throughout, we'll be trying to inform you about some of the legal nuances and clinical nuances that hopefully will help you do your work, whether you're a lawyer or a mental health professional or some other kind of scientist. Now, I'm curious, one more poll from you. How many people have either done a competence evaluation or made a motion for one? Made a motion for a competence evaluation. Okay, most of the lawyers in the room, I assume, have, because it's a very common phenomenon. Of all the forensic mental health issues that we have in the system, and includes the insane defense, mitigation and sentencing, diminished capacity, and so on, competence is the issue that comes up most often. It's the issue in which mental health professionals are called upon to inform the courts using their expertise about an issue the law is interested in. So that's one reason we're starting with competence to proceed. There are a lot of other issues we could be talking about. We could be talking about the insane defense. We could be talking about the death penalty. A number of other issues involve the intersection of psychology and psychiatry with the criminal law. But in terms of numbers, this is really the most important. And since it really comes at the beginning of the criminal process, in many ways it's also practically the most important. So I want to start by talking about the definition of competence to proceed. And I'm going to break it into 2 different components. One is what is often called adjudicative competence. Okay, that is competence to be adjudicated. That is competence to understand the adjudication process. And then on the next slide, I'll be talking about a different component of competence to proceed, which is what's sometimes called decisional competence. Because defendants, of course, have to make decisions throughout the process. And there's a different kind of inquiry that goes on with decisional competence as opposed to adjudicative competence. I hope I'll make that clear. as we go through this. Well, this is the key case. Again, I'm going to keep on taking polls because I'm really curious. I want to get a read on the audience. How many people have heard of this case, Dusky versus United States? Okay, not too many. It is really the key case in this area. You need to know about it. Okay, it's a United States Supreme Court case, and it is the case that came up with the language that has now been adopted in every jurisdiction in this country defining competence to proceed. Interestingly enough, this language came from the Solicitor General's brief and was not even a formal proposal by the Solicitor General as to what the test should be, but the United States Supreme Court nonetheless adopted it, and it's now become the law of the land in terms of how we define competence. So I'm going to read the language to you just because it is so important. The test competency must be whether the defendant has sufficient present ability to consult with his attorney with a reasonable degree of rational understanding and a rational as well as factual understanding of proceedings against him. Okay? That's the test for competence. I want to emphasize several aspects of it. First of all, it focuses on two different things. There are two different prongs to the Dusky test. At least most people think that's the case. One is the individual able to consult with his or her attorney? That's obviously key. If the person can not communicate with the attorney, we're not going to have a meaningful process because the defendant will not be able to tell his attorney whether or not the guy on the stand is a lying SOB, where the alibi witness is, where evidence might be found that helps exculpate the defendant. And additionally, the second prong is the individual has to be able to understand the proceedings. What does the prosecutor do? What does the defense attorney do? If the individual has no understanding of how the process works, then once again, we need to be concerned about the nature of the process and especially the reliability of the process, a point I'll come back to in a second. So those are the two prongs of Dusky, and in a little while I'm going to try to operationalize those in a little bit more detail. But that's the key thing to have in your head, two prongs connected with Dusky, the Dusky test. Second issue, and this is one that, at least in the old days, a lot of lawyers and medical professionals were confused about. Competence is focused on present mental state. Okay? Does the person right now have the ability to consult with the attorney and understand the proceedings? You sometimes saw, especially in the old days, this kind of phrase, insanity at the time of trial. Insanity defense is not this. Competence is about present mental state and the two prongs that I just described. The insanity defense is about mental state at the time of the offense. It has to do with whether or not the person is blameworthy for the offense they committed or instead blameless because of mental disability. It's very possible for a person to have been insane at the time of the offense, but competent at the present time to undergo trial. And in fact, we could never have an insanity trial unless the person was competent to undergo that trial, right? So a person might be insane at the time of the offense, but through either medication or some other kind of treatment, or maybe even natural remission, they become competent at the time of the trial. Two totally different issues. One has to do with past mental state. This has to do with present mental state, okay? The person's present mental state. Thirdly, Dusky uses the word reasonable degree of rational understanding, as well as factual understanding of proceedings against him. Reasonableness, for those of you who are not lawyers in the room, all you lawyers know this already, reasonableness is the ultimate legal weasel word. If we don't know what the test should be, we just say, be reasonable. Be reasonable about the standard. And that's what's going on here. This is a test about whether the person has a reasonable degree of rational understanding about the process and the factual underpinnings of the case. Research tends to show that about 30% of those people who referred for an evaluation of competence end up being found incompetent, which means what? A large number of people who lawyers suspect might be incompetent are nonetheless found competent. Roughly 70% of those referred for competence are found competent. Only 30% are found incompetent. Now that's basically an amalgam of several studies. Some studies find higher percentage, some a lower percentage. But that gives you a nice, I think, heuristic, a base rate for incompetency findings. And what I'm trying to suggest here is this means that just because a person has some mental issues doesn't mean they're incompetent. We're talking about a reasonable degree, and that does not require a college level or even high school level of understanding. It just requires enough for government work, enough to get through a trial with the help of an attorney or through a guilty plea process with the help of an attorney. A fourth aspect I want to emphasize is notice that the word rational is used in the Dusky test. Okay? Now, this is a cognitive test. We're focused on an individual's ability to perceive what's going on and process what's going on. It's essentially a cognitive kind of inquiry. And in particular, it involves an understanding of the process, and it requires that the understanding be rational. And I want to come back to that in a second, because rationality is an incredibly amorphous word. Rationality can mean lots of different things. I mean, I probably engaged in several irrational acts from the time I got up this morning till right now, including not bringing an umbrella until the last minute, right? That you could call that irrational. Rational is an incredibly broadly defined kind of word. I want to talk a little bit more, and Eric, I probably will talk a little bit more about what that means in this particular context. And finally, and this emphasizes something I just said, this test is focused on cognitive functioning. Before I emphasize the word cognitive, now I'm going to emphasize the word functioning, because something that happens over and over again, I see it both with mental health professionals' reports and with lawyers, is they say, oh, the person has a diagnosis of schizophrenia or bipolar disorder. That makes them incompetent. No, no, no. Diagnosis is not dispositive of the competency issue. It is true that there's a higher base rate for incompetence among people with schizophrenia. There's no doubt about that. People with serious mental illness are more likely to be incompetent than people who do not have serious mental illness. But just because a person has schizophrenia does not mean they're incompetent. What is incompetence? What I just got through talking about. The person is unable to consult with the attorney with a rational degree of understanding. The person doesn't understand the proceedings. But if they meet those baseline criteria, they are competent, even if they have a diagnosis. It's an incredibly important point to make. We're talking about functional capacity, not diagnosis. It's particularly easy for mental health professionals to confuse those two issues. They figure if the person's got a serious mental illness, then the law must consider that person incompetent, and by the way, also insane. They often say that, too, when they're talking about mental state at the time of the offense. That's wrong. The law is focused on function and dysfunction, not diagnosis. Now, diagnosis can be certainly very relevant, but it's not dispositive. Okay, now, one thing I like to talk about briefly is why do we care about this? I mean, after all, 99% of the time, the defendant we're talking about has an attorney. One of the attorneys in this room, very competent individuals, legally trained. Why do we care whether the person's competent or not? It's like the lawyer can be a guardian. The lawyer can make decisions for the defendant. We don't need to make extra sure the individual has mental capacity. Well, I've already alluded to why. We want to make sure the process is reliable. And if the defendant's not able to communicate with the attorney about the facts relevant to the offense, only the defendant really knows what happened at the time of the offense, whether the defendant was there at all, and if the defendant was there, who else was there, whether there's a co-defendant, whether there's any evidence that might be discoverable through investigation. If the defendant can't communicate those kinds of facts, then we have a problem with reliability. It might not be a truly adversarial contest because the defense is handcuffed by the fact it doesn't have access to all the facts the defendant knows about. Okay? So that's the main reason we require this. The second reason is what might be best called dignity or integrity of the process. Even if we know the process is going to be reliable. If the defendant is sitting next to the defense attorney in the courtroom and drooling out of the side of his mouth and looking up at the ceiling, clearly having no idea what's going on, we don't want that process to take place. That would say a lot of bad things about us as a society if we allowed that trial to take place, even if we're absolutely sure the outcome is reliable. So those are really two different reasons, very important reasons for why we care about this. And those reasons are essentially recognized in the United States Constitution. I have up here Sixth Amendment and due process. The Sixth Amendment, as many of you know, includes among the many rights listed there the right of confrontation. Okay, a defendant has a constitutional right to confront his or her accusers. Well, being physically present isn't enough. Okay, just because the defendant's sitting next to defense counsel doesn't mean you're having an actual confrontation. The defendant has to be mentally present, or you cannot have an actual confrontation. So you could say this requirement of competence comes directly from the Sixth Amendment. There's no real meaningful right of confrontation unless the defendant is mentally present, meets the two prongs of Dusky. And secondly, we have the Due Process Clause in the 5th and 14th Amendments of the Constitution. And you lawyers in the room know that due process is sort of the basket category which protects all individuals subject to legal process. The Due Process Clause more specifically says a state may not deprive a person of life, liberty, or property without due process of law. Of course, the $64 million question is, what is due process of law? Well, I'll tell you the answer, and you get $64 million. You have to be fair. Okay, but different contexts require different types of fairness. In this context, due process means we have an unfair situation, we have an unfair deprivation of life, liberty, or property unless the person meets the two prongs of Dusky, unless the person is able to talk to the attorney and understand the process. So there are constitutional background and constitutional backbone to the competence requirement. So that's a general introduction to the competence to proceed issue. I want to emphasize several aspects of it, especially with respect to adjudicative competence, that is competence to be adjudicated. The first is this. We're talking about capacity to deal with both prongs of Dusky. Capacity to deal with both prongs of Dusky. Now, anyone who's been involved in evaluation knows that sometimes you ask a criminal defendant in a competency evaluation, well, what are your charges? And they go, I don't know. Why? Because his or her attorney hasn't told him, or maybe he was told it, but it was 3 weeks ago. He doesn't remember exactly what they were. Does that make the person incompetent in terms of not being able to understand the charges? Obviously not. We're talking about whether the person has the capacity to understand the charges once he or she is told about those charges. Same thing with all the other things I'm going to be talking about. So that's the key issue. So what does the person have to have the capacity to understand? Well, the charges and consequences of those charges. Pretty obviously, if the individual doesn't have the capacity to understand his or her charges and what could happen if they're found guilty or not guilty by reason of insanity or straight out not guilty, that's a problem. They have to understand charges and the consequences. So I only want to emphasize one thing here. Remember, Dusky talks about a rational understanding of the charges? So this reference here to Jesus Christ 2000 was an actual case that I was involved in as a lawyer. But a friend of mine, an evaluator, Norman Poitras, was doing the evaluation back in 1998, a long time ago now. The individual who was evaluating was charged with 3 counts of armed robbery in the state of Florida. And in the state of Florida, armed robbery comes to the maximum sentence of 15 years. So Norm asked during the competence evaluation, what's the penalty for armed robbery? And the defendant said 15 years. I said, well, so what do you think the consequences of a conviction will be? Well, it could be 15 years times 3. 15 years times 3 counts. A+ answer. Incredibly good answer. Okay, better than your typical answer from people who undergo these kinds of evaluations. But later on during the evaluation, Norm asked, okay, well, so if you're convicted, you end up in prison, what's going to happen? And the guy said, well, I'm not going to prison even if I'm convicted. Or if I do get convicted and go to prison, I'm only going to be there a very short time. And I said, well, but you just said if you're convicted, you could get a maximum penalty of 45 years. So what do you mean? He says, well, I'm Jesus Christ. And in a year, God's going to recognize that I'm Jesus Christ and free not only me, but every other prisoner in the state of Florida and kill the governor. Oh, okay. Well, that puts a slightly different light on his understanding of the charges and consequences. Yes, in an abstract way, he understands the charges and the consequences. But does he have a rational understanding of those charges and consequences? Arguably not, right? And in fact, he was found incompetent. Person also has to be able to understand the nature of the adjudication process. As I mentioned before, what does the prosecutor do? What does the defense attorney do? What does the jury do? Now, it may be that during the evaluation, the person doesn't have a perfectly good understanding, but remember, we're talking about capacity. Many of the people referred for evaluation can be informed about these issues and have the capacity to understand them. The only thing I'll mention here is that sometimes you come across a cynical defendant. You're asked, okay, what's the role of the defense attorney? Oh, his job is to work with the prosecutor to convict me, right? Well, what's the role of the judge? Well, he basically gets the jury to convict me. Well, is that irrational? Is that incorrect? Yeah, maybe. I hope it's incorrect. But it might just be the view of a cynical defendant who's been through this before, seeing the prosecutor and the defense attorney hobnobbing in the hallway, probably doing a plea deal, but nonetheless, it looks suspicious to the defendant. The job of the evaluator, like Eric, is to differentiate between the cynical but rational defendant and the one who, because of serious mental illness, is irrationally paranoid about his defense attorney and so on. That's where the evaluator comes in very handy, is trying to differentiate between real irrationality based on severe mental illness and something else. And then, this is really the most important aspect of this, capacity to recount pertinent facts. If the defendant cannot recount pertinent facts, offense about the time period of alleged offense, then we can't really have an effective proceeding. Sixth Amendment, will be undermined because we cannot confront the defendant's accusers. I just want to mention a couple things here. Eric, are you going to talk a little bit more about this later, or not?
I'll make a point of mentioning U.S. v. Wilson.
Yeah, okay, so some of what I'm going to say will be elaborated upon by Eric, but in any event, I do want to mention Wilson. This is not a United States Supreme Court case. It's a District Court of Columbia appeals case, excuse me, but it is considered to be the leading case on the relevance of amnesia to the issue I'm talking about here, that is capacity to recount pertinent facts. Now, research has shown that in about 40% of all homicide cases, there is a claim of amnesia. Why? Defendants say, hey, if I say I can't remember, maybe I'll get off. Well, that's wrong. Okay, amnesia is not a defense to any crime, but nonetheless, there are many claims of amnesia, not just in homicide cases, but in many other kinds of cases as well. Sometimes that amnesia is real. It might have been the case in Wilson. What happened in Wilson? Wilson and his co-defendant were charged with armed robbery of a store. Okay? What happened apparently was that they robbed the store, and in trying to get away, they hit a tree. Horrible crash. Wilson had a major concussion, and he apparently legitimately had real retrograde amnesia. He did not remember what happened at the time of the offense. And at least the Wilson court assumed they didn't know what happened at the time of the offense. So his argument was, I can't be competent to stand trial. I can't talk to my attorney about what happened at the time of the offense. And maybe I didn't do it at all, or if I did do it, maybe I was there at the store, but maybe my co-defendant was the one who planned it. He was the one who pulled the gun. All sorts of mitigation might be available to me if I had the ability to remember what happened, but I can't, so you can't find me competent. And the D.C. court said, oh, yes, we can. Okay? Amnesia per se is not a bar to a finding of competence. However, the Wilson court then went ahead and said, however, if it really is amnesia, you need to have a super fair trial. The prosecution has to bend over backwards, give the defense the relevant files. The judge has to make sure the trial is as fair as possible. Of course, you're wondering, well, why is the judge always trying to make sure a trial is as fair as possible? But nonetheless, that's what the D.C. court said. And if at the end of the trial, the judge thinks this wasn't fair, the amnesia really did affect the fairness of the trial, then the judge actually can annul any conviction that takes place. But the trial can take place. That's the main point of Wilson. Amnesia per se is not a bar to a finding of competence. So what that means is all these factors I'm talking about are just factors. Okay? And what ends up being the case in most situations is it's a multi-factor totality of circumstances kind of analysis by the judge after hearing the lawyers argue and seeing the reports from the mental health professionals in terms of deciding whether the case should go ahead or not. And it can be very contextual because a factor I don't have here on the slide is the legal context. One case I was involved in, individual charged with driving with a suspended license. Now, why he was even being prosecuted is unclear to me. I'll talk about that a little bit later. But he was being prosecuted for driving with a suspended license. And his attorney was alleging incompetence. Okay? Now, we did an evaluation of him, and he had severe organic problems. Some of you may know what a mental status exam is. He had a very hard time with the mental status examination. He couldn't count backwards from 100 by fives. He didn't know what to do with an envelope found on the sidewalk, that kind of thing. So pretty basic impairment, pretty substantial impairment. But at the same time, he knew that when the police found him, he was driving with a suspended license. He knew what a suspended license was. He knew he was behind the wheel of a car when they stopped him. And the judge ended up finding him competent because he understood the basics of what he needed to know for this kind of proceeding. What if he'd been charged with securities fraud? No way he would have been found competent, right? There's absolutely no way. That's the point I'm trying to make. Legal context has a whole bunch to do with whether someone's competent. The exact same person can be incompetent in a complex situation and competent in a not very complex situation. Okay? One last thing I have up here, just for fun, Morris versus Slappy is not a competency case. It's a United States Supreme Court case that dealt with the claim by the defendant, well, I was able to recount pertinent facts to my attorney, but we just didn't get along. You know, I mean, he and I were at loggerheads. And some of you who are attorneys in the room probably know what I'm talking about. Sometimes you have that client who's just a real blankety blank, right? It's very hard to deal with, and the client probably returns the favor, thinks you're not so easy to get along with either. So that was a claim made, that it was a violation of the defendant's right to effective assistance of counsel, that there wasn't a good relationship between the defendant and the attorney. And of course, you know where this case came from, the Ninth Circuit, California. touchy-feely. Everybody gets a lovey-dovey relationship, right? Well, the Supreme Court slapped that down immediately, and more for slap, they said that's ridiculous. Yes, you have a right to effective assistance, but you don't have a right to a perfect relationship with your attorney. That's not part and parcel of the competence issue. Can you see that? Yeah, just barely. One last issue. Remember I said most of the focus here is on present mental state, But a competence evaluation does have a bit of a predictive aspect to it. Why? Because not only do we have to make sure that at the present time the person understands the charges and the consequences, we have to make sure they will, at the time of trial or guilty plea hearing, will also have that understanding, and more importantly in terms of prediction, that they won't fall apart during trial to the extent they're no longer able to talk to their attorney. You could certainly have a person who's completely functional within the evaluation room or within the lawyer's office. But when you get to trial, you know how stressful it is. If you've ever been an expert witness or a lawyer in the courtroom, the lawyers are stressed out, right? Well, imagine what it's like to be a witness on trial in a capital murder case or even in a garden variety case. It's very stressful. Get on the stand, a mentally ill person can decompensate. So there needs to be a little bit of prediction involved here as well. And Allen versus Illinois, some of you may know, has to do with this situation. An individual who probably wasn't severely mentally ill, but had some mental problems and kept on interrupting the proceedings. Stood up, shouted at the judge, shouted at the lawyers, and eventually was removed from the courtroom. And his conviction was later challenged, got to the Supreme Court, on the grounds, hey, this violates due process. You undermine my right to confront my accusers by taking me out of the courtroom. The Supreme Court said, well, we don't think your right was violated. The judge basically has three options in this situation. If the guy's being very, very egregiously disruptive, you can bind and gag him and allow him to sit next to the defense attorney, but that's not very useful. First of all, it looks very bad in front of the jury. Secondly, he can't communicate with his attorney. Or you can hold him in contempt. But in a capital murder case, what's the defendant's worry? Okay, another 6 months added to a death penalty? I'm not too concerned. So thirdly, take him out of the courtroom. Now, nowadays, with all the technology we have, that's not a bad option, right? The person can still observe the proceedings. The point I'm trying to make here is that Allen recognizes that disruption of the courtroom can be a factor that is relevant to whether or not a person's either competent or the proceeding can go forward. That's something the evaluator and the defense attorney need to think about in doing a competence evaluation. Will the person be able to hold it together in the stress of trial? So there are a lot of other factors that are nuances of what I've talked about, but I think these are the key factors that a person has to have the capacity to deal with. And all that, by the way, is dealt with standard 4.1, as you see at the top of the slide. Remember I said there are two different aspects to competence to proceed. One is adjudicative competence. The second is decisional competence. Simply because a person has a rational, factual understanding of the proceedings, that doesn't necessarily mean that the decisions they make will be competent, okay? And the reason I'm stressing this as a separate component of competence to proceed is that here we're talking about a different rationale for the competency requirement. Remember, the rationale for competence to be adjudicated is reliability. We want to make sure the process is reliable. The rationale here for making sure a person is decisionally competent is not reliability. You could argue it has nothing to do with reliability. It has solely to do with autonomy. It's whether the person, at the time of making the decision, is an autonomous actor. Okay? You could have a decision, and you attorneys in the room probably confronted this situation. You can have a defendant who is competent in the adjudicative sense. He understands proceedings. He knows the pertinent facts and to communicate them to you. But he wants to go to trial. And you, the attorney, are sitting there thinking, that is a stupid idea. You go to trial, you're going to go down for a very long time. I've got this great deal from the prosecutor, we should take it. But the defense saying, no, 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 I want to go to trial. Okay? And the lawyer might be right, the defendant may be totally wrong. That the outcome at trial would be horrific and unreliable in terms of what would be the right outcome. The guilty plea would be a better way to go. But if the individual defendant is autonomous, he gets to control that decision. It may be an unreliable result, but it still stands because the individual is an autonomous individual, and under the law, the defendant gets to decide whether to go to trial or plead guilty. So reliability is not the rationale here. It's autonomy. Is the individual an autonomous actor? And this issue is a very important one because it can often create a lot of tension between the attorney and the defendant. There are times when a defendant wants to do one thing and the attorney wants to do another. And if the defendant is competent and it's the kind of decision the defendant gets to make, attorney loses, defendant wins. Okay? A key case here from the United States Supreme Court is Godinez versus Moran, which dealt essentially with decisional competence. What happened to Moran? This is a guy who was charged with 3 counts of capital murder. Okay? And then he tried to kill himself. Well, he blew it. He didn't kill himself. So he was prosecuted on 3 counts of capital murder. Several mental professionals found him competent to proceed. They did see evidence of depression on the part of Moran, but basically they'd found him competent to proceed, and the judge agreed. He later fired his attorneys, pleaded guilty, and then at the capital sentencing proceeding, didn't present any evidence. So not surprisingly, he was sentenced to death. Okay? He's sitting there on death row. About 4 months later, he says, what the hell was I doing? Firing my attorney, pleading guilty, not presenting any mitigating evidence. And he got an attorney to bring a case for him that ended up in the United States Supreme Court. And his argument was, okay, I might have been competent to stand trial, but I wasn't competent to plead guilty, and I wasn't competent to waive an attorney, and I certainly wasn't competent to represent myself, and I wasn't competent to waive mitigating evidence at capital sentencing. I wasn't competent for any of those purposes. That was his argument. He lost that argument. Okay? And he's now dead. He's been executed. The Supreme Court held that if you're competent to stand trial, in the adjudicative sense, if you understand the proceedings and understand pertinent facts, you're also competent to plead guilty. Now, the Ninth Circuit had said, no, that's not true. Simply because you're competent to stand trial does not mean you're competent to plead guilty. Why? When you're pleading guilty, as opposed to when you're standing trial, you're waiving all sorts of rights, right? When you plead guilty, you're waiving the right to remain silent. You're saying, I did it. That's a major waiver of the right to remain silent. You're waiving your right to trial counsel. You're waiving your right to jury trial. You're never going to see a jury. You're waiving your right to confront accusers. You're never going to see your accusers if you're pleading guilty, right? So you're waiving all those rights. That's a bunch of waivers. You should have to be more competent, higher level of competence. Supreme Court disagreed with that reasoning. Once again, reverse the Ninth Circuit. Those of you who are lawyers in the room know that's typical, right? Reverse the Ninth Circuit, and what the court said is, look, even a person who goes to trial has to understand the right to jury trial, because the defendant has a right to waive a right to jury. Even the defendant who goes to trial has to know about the Fifth Amendment because he has to decide whether to testify or not. That's either giving up the right to remain silent or asserting it by staying next to the defense attorney. You have to understand all the rights, whether you're going to trial or pleading guilty. So the court said if you're competent to stand trial, you're competent to plead guilty. But the important point here is that means, since 95 to 98% of all cases are resolved through a guilty plea, not a trial, that the evaluator and the lawyer have to make sure that the defendant understands all these rights very clearly. Okay? It's not enough to just do a pass-over. Oh, do you understand the right to remain silent? Yes. Okay, next question. You've got to make sure they understand the rights and what happens when you plead guilty, that you're giving up that right when you're pleading guilty. Okay? Moran also held this, which is even more controversial. If you're competent to stand trial, you're also competent to waive counsel. Now, of course, Moran's lawyers argue that's ridiculous. I've already established competent to stand trial, competence to proceed. It's a pretty low level of competence. Just because you're competent to proceed doesn't mean you can go in a courtroom and represent yourself and do anything but a horrible job. I mean, even a high school or college graduate has a fool for a client, right? When they represent themselves, you've heard that saying. So especially a mentally ill person, bad idea, right? But what the court said is, look, we're not talking about whether or not the person will do a good job in the courtroom. They probably won't do a good job in the courtroom. But under Feretta versus California, we, the Supreme Court, have already held you have a right to represent yourself. Under the Sixth Amendment, you have a right to represent yourself. You have a right to waive counsel, even if it's an idiotic move. You have a right to do it. And we're not going to reverse Feretta. So the issue in this case is not whether you're going to do a good job in the courtroom. It's whether you are competent to make the choice to waive counsel. It has nothing to do with what you're going to do after you make that choice. It has only to do with whether you're an autonomous actor at the time you choose to waive counsel. Do you understand the consequences of waiving counsel? If yes, go right ahead. Be my guest. Represent yourself. Okay? Even if you do a horrible job of it. And further, though the court didn't hold this, it probably means if a person is competent to stand trial, they're also competent to waive an insanity defense, which is an issue that comes up fairly often. A mentally ill person, lawyer thinks best defense is insanity, right? But often defendants deny the mentally ill at all, have a lack of insight is often the phrase you see. And they say, no, I don't want an insane defense. Remember the Unabomber case? That's what was going on in that case. Ted Kaczynski, his lawyers wanted to assert an insane defense. He said, I'm not mentally ill, despite voluminous evidence that he was. So you have that clash. The only issue here is who gets to decide the insanity issue. It's absolutely clear that defendants control the guilty plea decision and control the decision about waiving counsel. It's not as clear that the defendant, as opposed to the defense attorney, controls the insanity defense decision. If you, a poll of attorneys found that about 35% of attorneys polled thought they should control the insanity defense decision because they think it's a tactic, not an objective. But I think my personal opinion is that's wrong. The insanity defense should be an objective. The defendant should control the decision about whether to insert the insanity defense. It's after all their life. They should be able to decide whether they're called criminally insane or not. And so it should be their decision. But that's an open issue in some jurisdictions. If it is the defendant's decision, then if they're competent to stand trial, presumably they're also competent to waive an insanity defense. But Moran leaves a lot of issues open. Let me say one more thing about Moran. The court also said that even if a person's competent, the waivers involved with guilty pleas and waiving counsel have to be, as it says here, knowing and voluntary. Notice the word intelligent is not there, as it often is in waiver language, because it's never intelligent to do this kind of stuff. At least waiving counsel is never intelligent. But nonetheless, it has to be knowing and voluntary. What does this mean? All that means. It doesn't mean it has to be a good idea to plead guilty or waive counsel. All it means is the individual actually understands the consequences. Competence is about capacity, remember? Does the person have the capacity to understand this stuff? The knowing and voluntary issue is, do they actually understand what happens if you plead guilty? What happens if you waive counsel? So there are a couple of questions left open after Godinez, and they might come up in a guilty plea situation or a waiver of counsel situation, and sometimes you might, as an attorney, want a separate evaluation if there's disagreement between you and the defendant on pleading guilty and waiving counsel. The first issue is, let's say the guy does want to waive counsel. Does the individual have to understand more facts than if he's going to trial with counsel? And one might argue yes, because even though the court in Godinez said if you're competent to stand trial, you're competent to waive counsel, when you think about it, if you are actually going to be in that courtroom by yourself, or with standby counsel, but basically by yourself, you have to know what an opening and closing argument is. You have to know, at least in general, what the rules of evidence are. You have to know what jury selection involves. And arguably, that's more factual information than would have to be understood by a person who's going to trial with counsel. So that's one open question, and 5.3b of the ABA standards alludes to that. More importantly, and this is really important, remember that word rational and Dusky. How important are the reasons the defendant gives for pleading guilty or waiving counsel or waiving the insanity defense? I would argue they're incredibly important. Okay, if the guy says, I want to plead guilty because I want to have my day in court, and I don't care that if I go to trial and get convicted, I might get 10 more years than the plea that's on the table, that's pretty rational. It might be stupid, but it's a rational decision. If, on the other hand, the guy says, I want to go to trial because otherwise my head will explode, that's a different kind of reason that arguably is very relevant to whether someone's decisionally competent. Okay? Unfortunately, Godinez versus Moran doesn't make clear how relevant reasons are to this decision. The court never once mentions the reasons Moran gave for finers attorneys, pleading guilty, and waiving mitigation. It doesn't even talk about them, which I think is pretty stunning. But nonetheless, if I'm a lawyer on the other side, I argue, well, look, reasons aren't important. The court didn't talk about any reasons. I think they are very important in terms of the rationality inquiry. And so I would suggest that at the least, a person should give reasons that are not based on delusions. And Eric can talk more about what delusions are, but basically it's a fixed false belief. That is, a false belief that's basically so fixed that you can't budge the person off the dime. They believe their head will explode no matter what, okay? So if they have delusional reasons, then they're incompetent decisionally, or even if they're not delusional in terms of their reasons, they lack what could be called basic self-regard. What am I talking about here? They basically have abdicated their will. Okay, to use a clinical term, they're clinically depressed. They basically have given up. I think this was true of Moran. Moran actually had a fairly high IQ. He understood his charges. He understood the consequences of those charges. He knew the pertinent facts. In fact, he recounted them to the defense attorney and to the judge at the guilty plea hearing. But he probably was clinically depressed. Even the psychiatrist who evaluated him thought maybe he was clinically depressed, which means what? He just didn't care about anything. In fact, he later said, I didn't care about anything. That's why I did what I did. I wasn't exercising my will. I had no self-regard whatsoever. And I would argue that's also grounds for finding someone incompetent. Now, I want to emphasize, this is my own personal opinion here. This is not the law anywhere, but I think these are issues that ought to be considered at the least by the judge. On the other hand, I don't think a person should be found incompetent simply because the lawyer thinks it's an unreasonable decision. Okay? That goes back to what I said before. Just because a decision seems unreasonable to a lawyer does not make it incompetent. It has to be delusional or lacking in basic self-regard. So this is an important issue, and I have one more slide, which I'm going to go over very briefly, and then I'm going to hand it over to Eric. But this is an important ethical issue for the lawyers in the room. What if you think the defendant is of doubtful competence? Okay? So your inclination is to get an evaluation of competence. But the defendant says, I don't want to be evaluated for competence. I'm not mentally ill. I don't want to see a mental health professional. Keep me away from those mental health professionals and those hospitals. And to make it even worse, the prosecutor has offered you a very juicy deal, right? That if you accept, will get your client very little time, maybe even time served. Whereas if, hey, you get a competence evaluation, he'll be in the hospital for a while, and then after that, there may be a trial, and who knows, he may be convicted and get a lot more time than the deal. What do you do in that situation? And I think those of you who are lawyers in the room probably have been confronted with that situation. The old standards, the standards that we revised, said you still have to raise the competency issue. You still have to make the motion for the competence evaluation. Why? As a defense attorney, you are an officer of the court. And it would be misleading the court not to raise the issue. Plus, it may look like a good deal now, but now he'll have a conviction on his record. Who knows? He might not be guilty at all, or that conviction may be used as an enhancement later on in a way that isn't good. And if you don't get treatment for him, if he's incompetent, he probably needs treatment, you don't get treatment for him, he's probably going to be back in court 2 weeks from now, or 4 months from now. The mental issues will not have been taken care of. So that was the reasoning of the old standards. But the new standards say something different. The new standards leave it to the discretion of the attorney whether or not to make the motion for competence, because of the various kinds of considerations and incentives that are involved, and also because, as I'm going to talk about here in just a second, the defense attorney can tell him or herself, hey, even if I don't raise it, the judge or the prosecutor can. Now, of course, they're not as likely to notice it as a defense attorney, but nonetheless, the defense attorney can tell him or herself, if it's a real problem, it'll get raised by someone else. Now, can it get raised by someone else? Yes. Drope versus Missouri said, in fact, it's an obligation on the part of the judge to raise the issue, even if the defense is not raising it, if it becomes clear the person's incompetent. Why is that? Because not only is competence to proceed the right of the defendant under the Sixth Amendment and under the Due Process Clause, the state has an independent interest in making sure people who are tried are competent. Remember that thing about dignity I talked about earlier? The state has an interest in making sure proceedings are dignified, and also an interest in making sure proceedings are reliable, independent of anything the defendant might want. In fact, maybe the defendant doesn't care about reliability. The state still should. And so the state has an interest in making sure a person's competent, and so the prosecutor and the judge can raise it as well. And that is one reason why the new standards say we leave it up to the defense attorney whether or not to raise the competency issue in the scenario I talked about before. I think it's a very interesting issue. I actually don't like the new standards, just so you know. I like the old standard, but nonetheless, the new standard says that, and that was the resolution of the ABA. What should the motion state? Again, there's an ABA standard on this. Good faith bona fide doubt is the standard adopted by the United States Supreme Court in Pate and Drope. And the only thing I want to emphasize here is defense attorneys should not make a competency motion simply to delay the process, or simply to get information about treatment, or simply to get information that might be useful in a plea bargain. There should be a bona fide doubt about competence, or the evaluation should not be made, a motion should not be made. A competency motion should not be used for hidden agendas. If you've got other agendas, use other avenues for getting that information. Don't use the competency evaluation as a ruse for getting other kinds of information. Same thing with the prosecutor. Prosecutor shouldn't make a competency motion just to get a person off the streets. Okay? There should be a bona fide doubt about competence. And the motion should include specific facts. It's incredibly useful to evaluators like Eric to have some clue as to why the defense attorneys or the prosecutor or the judge thinks the individual is incompetent. The ABA recommends that the competence evaluation be separate and apart from the evaluation of mental state at the time of the offense. That's what MSO stands for. Separate and apart from the insanity defense evaluation. Now, most jurisdictions are often combined, and if that's the way it's done, well, that's the way it's done. But the ABA prefers that they be kept separate. Why? You're much more likely to reveal self-incriminating information in an insanity evaluation than in a competence evaluation. All you're talking about in an insanity evaluation is what happened at the time of the offense. A lot of self-incriminating information is going to come out during that evaluation. It would be nice if the report didn't have all that information in a document that's going to go to the prosecutor and is going to be used, at least initially, only to resolve competence and not resolve insanity, especially if the individual never ends up asserting an insanity defense. And you got all this self-incriminating information in front of the prosecutor that will never be relevant to any defense by the defendant. So we recommend keeping those evaluations separate, or at least keeping the report separate. A competence report and an insanity report, keep them separate and send them out only when they're relevant. Where should the evaluation take place? I know in most jurisdictions it's in the hospital. The ABA takes a very strong stand. Ideally, these evaluations should take place on an outpatient basis, either in jail or if the person's released, obviously in the community. There's no need to put most of these people in the hospital for an evaluation. Evaluation doesn't take that long. You don't need to send them to the hospital for 6 months just to do an evaluation. So that's the strong recommendation of the ABA. Who can perform it? I think many lawyers are used to psychiatrists doing this stuff. It doesn't have to be psychiatrists. Social workers and psychologists can be qualified if they've gone through the appropriate training to do these evaluations. It's not as complicated as an insanity evaluation or as a mitigation evaluation, sentencing. So a number of different types of mental health professionals can do it, and the ABA standards recognize that. What should the report on competence include? Obviously, it should reference the Dusky criteria. And here, what I want to mention is this ultimate issue. Should the report say in it the defendant is competent or incompetent? I think, generally speaking, probably yes. Why? Because that's what lawyers want. That's what judges want. If it's a 10-page report, they're still going to turn to that last page and see what the ultimate conclusion is before they read the rest of it, and maybe without even reading the rest of it, which is one reason I don't like ultimate issue language, is because the judge just abdicates to the mental health professional in many situations. But probably should include it because lawyers and judges want that language. However, what we recommend in the ABA standards to the evaluator is that there be cautionary language in the report saying something like this. It is my opinion, based on my understanding of the legal test of competence, this person's incompetent or competent. Make it clear, it's not the evaluator's job to decide whether someone's competent or incompetent. That's why the judge gets paid big bucks, okay? So that's all I want to say about that. The report should also address how a person would be restored to competence if, in fact, incompetence is found, and where that restoration should take place. Again, the ABA standards emphasize outpatient as opposed to inpatient. These people often can be restored to competence on an outpatient basis. A number of states, but the separate problem is this. A lot of times, restoration has to take place in a hospital. It's the only way we can really restore a person to competence. Some states don't allow hospitalization to take place for restoration purposes unless commitment criteria are met, and many of you know commitment criteria require dangerousness. Well, sometimes these people found incompetent are not dangerous, and yet they need hospitalization to restore them to competence. That's a real problem. At least technically, you need to hospitalize them and restore them, but you can't send them to the hospital because they aren't dangerous. I think states that have this problem ought to change it, and the ABA standards make it clear that dangerousness should not be a commitment criterion here when we're talking about restoration. And finally, the report, as I already alluded to, should not include self-incriminating information. The competency report should not include self-incriminating information. It can say the defendant could recount pertinent facts about the offense. The defendant understood what the police report said about what happened at the time of the offense, but you don't need to go into gory detail. Yeah, then the defendant shot the victim at point-blank range and threw the murder weapon into the bushes at First and Main. By the way, prosecutors go look for the gun there. Okay? Don't need to include all that stuff in a competency report, which is only about competence. It's not about mental state at the time of the offense. I know I've gone through this very quickly, but I want to give plenty of time to Eric. So, Eric, you're up.
Thanks, Chris.
I'll be back.
Thank you. hard act to follow as always. I want to start out briefly by just thanking our hosts and everybody for coming out to hear about these things today. I was very flattered to be asked to do this. I thought they had finally recognized my preeminent brilliance. Then I realized when I talked to the folks at CLE Marketing, they just wanted to find a guy whose name rhymed with Slobogin because it would be snappier for selling tickets. I was even less thrilled to find out that Ken Hogan had turned them down. Mary Alice Logan was away on vacation this week. But this is what you get. And all joking aside, I'm delighted to be here. Briefly on CLE requirements and materials, please feel free to contact me at this email address. Next year we'll talk about narcissistic personality disorder and email handles, because anything that you did not actually receive or was too big to download, I can turn into a PDF and send it to you. Delighted to do that. Written materials weren't referenced before, but you have an article on competency to stand trial in a book by our Elizabeth Kelly at CJS Counsel in the back row over here. And by the way, if you're at Loose Ends this evening, Elizabeth will be moderating a panel on navigating the criminal justice and mental health systems at the Town and Village Synagogue on 334 East 14th here in Manhattan. There's also an article on psychology and an article called "The Doctor Won't See You Now, How Can They Judge Our Clients Without Meeting Them?" We may get into that a little bit, but when you have a competency evaluation, it's usually considered polite to show up, not just the defendant, but the doctor as well. I'm sure you've all of you practicing attorneys here run into the situation of reading a report by somebody who just feels compelled to proceed on the basis of records. And then, as was mentioned earlier by Chris, we will be looking at competency restoration. It's a hot topic these days. And then whatever else you like, any source that we mention in the course of these ravings, I will be glad to find a copy of it and send it to you. In putting this together, I gave a good deal of thought to what the audience would be like, criminal attorneys on both sides of the aisle. And I thought about that in terms of how are we going to approach the wildly esoteric notion of trial competency. Would they ever have encountered it before? And of course, I can't imagine that there's a criminal attorney in the room, prosecutor or defense attorney, who hasn't run into competency issues before. And then for the scientists, none of you are psychologists, so at least you get to bask in knowing just how difficult it is for psychology to measure up to what we might call the hard sciences in some of these areas. 100 years or so, we're still working on it. So I wanted this to be practical tools for the practitioners. I also wanted to throw in some new information of the type that you might not be hearing all the time, and then also to address directly the frustrations met by counsel in attempting to deal with mental health evidence. Because if we can't keep it real, then we'll get what you see from this candid shot of my own law and mental health students at the law school. You know, it's early in the morning, a break is looming, so we'll try to keep it snappy and indeed make time along the way for questions. Just please let me know if you have any questions about this stuff. So, who is it that is doing these evaluations? We have psychiatrists. They may be physicians, they may be osteopaths. Is there a preference? Not that I'm aware of. Psychiatrists focus in their training on psychopathology and how to treat it, and how to evaluate it. They, unlike the psychologists in virtually every jurisdiction, are authorized to prescribe medication. There's a movement in psychology to be able to prescribe medication. Let me speak from the lawyer perspective on that one. I think it's a terrific idea, because think of all the fantastic litigation that's engendered by having somebody go ahead and prescribe medication. Now, there are programs in which you can be a psychologist and learn how to prescribe medication. It takes 4 years. They have them in virtually every state. It's called medical school. What about the liver do you think that somebody handing out a pill should not know before they decide which one to do? This may put me somewhat at odds, at least historically, with what one of my guild organizations, the American Psychological Association, has thought Counsel usually doesn't have a hard time getting with that perspective. Their particular expertise is in distinguishing physically based from other mental disorders, psychopharmacology. They know about medication, neurological impairment. When your competency evaluation, prosecutors or defense attorneys, calls for something that is really more in the wheelhouse of the physician, it's worth considering when we're choosing our competency expert. Psychologists, Ph.D.s, PsyDs, Ed.Ds, that's Doctor of Psychology, Doctor of Education, also train on assessment and treatment of psychopathology. The expertise here is on psychological testing and other standardized assessment of intellectual functioning, behavior, academic achievement. Sometimes that's what the issue is likely to be. This is not to gate out the physicians, but when IQ and other related factors of intellectual disability, we used to call it mental retardation up until almost exactly half a dozen years ago. Something in your case may be more one than the other. I get called a lot where they say, you know, Doc, can you help us out? We think that this person was given the wrong medication. That's great, but you always have a short list of people from other disciplines to whom you can refer cases. Are the doctors themselves interchangeable? Are they fungible? Within the specific disciplines, not necessarily so, and as practitioners, you're going to want to look into the person's track record. You're going to ask them a little bit about what it is that they do and how they approach things. You know, Chris referred earlier to the idea from the standards about getting some input from counsel about what you need. If you are all grown up and you are an expert witness, you want to know what counsel's point of view is. So you want to know where this case is. You don't have to agree with it, but you want to know where things are going. And I would think that from counsel's point of view, you're advocates. This is what you do. Why would you want to pass up this opportunity? I'm always a bit surprised still when attorneys say, well, doctor, I don't want to bias you. Really? Because I'm kind of functioning a little bit, heaven help us all, as a judge on this limited issue. You want to plead your case. Again, you should expect your expert to be able to take these things with a grain of salt. All experts are not created equal, and when it comes, by the way, to the treatment that is a focus of restoration efforts, as we'll discuss a bit later, doctors come with different orientations. We spent a lot of time in my law school class talking about this. Some are more of a Ninth Circuit orientation, complete with leather elbow patches, and others not so much. You really want to check them out, get them in a conversation, and as a practical tip, ask them for something. You already have their CV, ask for it again. Write down when you asked for it. Write down when you got it, because in competency, as in other legal matters, time and timing can be everything. I want to alert you to something that Ken Melson asked us to include, and thank goodness that he did, and it has to do with the notion of cognitive bias. You hear an awful lot about this today. Cognitive bias, implicit bias. Be glad to send you a copy of this article by Patty Zapf and company. You may recognize Saul Casson as an expert on false confessions. What that research boils down to is this. They surveyed a ton of experts, and they found evidence for what they called a bias blind spot. Basically, experts willing to concede that bias happens all the time. In other experts, we saw that with a study that we did ourselves at Harvard on what it is that expert witnesses feel are important statements to make in court, beyond a reasonable doubt to a certain degree of this or that. We think individually that we know what these things are and have little faith in anybody else's ability to do it. Might be something having to do with the competitive nature of the expert marketplace. But what was pointed out is that evaluators who have training about these things, such as the training in which you're engaged today, are more likely to acknowledge bias as being a concern in these evaluations. You can ferret out the biases or lack thereof of the individual experts with whom you're consulting. You get into a conversation. You want to see if they can speak. It would be nice to meet them and see if they're going to look like an expert witness. I mean, who looks more like a mental health expert witness than me, right? right down to the beard and everything else, the natty little suit. And, you want to have somebody who fits the role, not the generic role, but the role you contemplate for your particular case. And for scientists, I mean, that's true of all the scientists, not just in the mental health professions. So we want to get a sense of who people are, how they can communicate, what their biases might be. And we don't want to make sweeping judgments on history. I got a call from a prosecutor recently, was looking for an expert witness in a case, and I knew just the expert that would be great, so I thought, for the prosecutor's case in that jurisdiction. Mentioned the name, he said, oh no, we can't trust her. She does a lot of defense work. To me, that elevated her from number one to, number something even higher on the list. Counsel, wouldn't you want that person if you check her out and realize that she's ready and willing to be fair? That would be a pretty useful expert. People can get typecast in some of these things. And it's funny, when you're in jurisdictions, I can think of one in particular, some nameless jurisdiction, which means that it doesn't help them for tourism, for example. I urge them to get a name that, in which I'm basically the angel of death, because the prosecution has called me on a number of capital matters. And then others where, what, really? Why would the prosecution ever hire him? He's a defense expert. If you tinker with these things, if you work directly, you may be able to fashion an expert for yourself that you might not have been seeking in competency matters. What about other professions? I'm not here to bash counselors, social workers, and the like, but we want to make sure that we understand the statutory requirements of the jurisdictions in which we're pursuing competency from either side of the aisle. Because I have seen cases, many of you probably have as well, where things get unpleasant really fast because we wound up getting an expert that did not exactly meet the requirements in terms of their particular profession, in terms of their experience. Some states actually, as we'll see, have requirements for who is allowed to do these things. Also with expert witnesses and competency matters, do we run into a bit of an identity crisis at times, whether they themselves really think they're the lawyers trying to get behind your desk as counsel? And how many times have you seen this logo or some version thereof on the business cards and letterhead and websites of the experts that you've retained? Probably quite a bit, right? What we're looking for is something to answer a legal issue, as Chris has addressed. Now here's a picture of the day that the DSM-5, exactly 6 years ago, came into our lab at Harvard Medical School. We were ready to go, as you can see from this picture, to pore over it. But this is what the doctors like to do. The physicians, whose book this really is, and the psychologists to some extent, could not agree more with Chris. It's not necessarily about a diagnosis. It can be helpful. We have to establish what's called the mental health substrate of competency. It can't just be because you don't understand what's going on in court because nobody told you, but they need to realize that what they're addressing is a legal matter. It is counsel's decision. Counsel, I tried to get a picture of somebody putting a saddle on an expert. I tried to steal that from the internet, but they were all so risque and they had like whipped cream and stuff, and I said, no, this is an ABA presentation. We're going to keep it clean, even if it is New York. So it's your decision. And there's something else too that I tell my law students, and after putting up with me for a semester, they have no reason to doubt it, that we do not assume that the experts are smarter than we are. They went to one school. As counsel, we went to another school. And there's no guarantee that they necessarily even know more in some cases about the mental health issues. Everybody has to start somewhere. And as the expert witness, there's a problem, and this isn't just for the mental health professional, but for all of us scientists. How many times have you had counsel, 28 years old perhaps, asking you what to do legally in a case? It's even worse in the case of those hybrids of us, and there's so many, who are attorneys as well as having a scientific background. Counsel's in charge. Even if counsel may not be right, whatever right is, if you open the door to letting the expert come in and try to call the shots on legal matters in competency evaluations, it can be a big problem. What about standards? First of all, I want to a shout out, and I know Elizabeth Kelly here, the author of the book, and also who will be co-authoring an article on on the criminal justice standards on mental health for Criminal Justice, our magazine. Those standards are incredibly helpful. Are they enforceable? No, but even if we are lawyers, not everything has to be enforceable. A terrific source of information about certainly the latest thinking in these areas. There are standards for the scientists. There are guidelines for the scientists. What's the difference between a standard and a guideline? This is a matter of some debate that has some significant ramifications for cases. A standard is, from the profession's point of view, enforceable. We go out of our way, particularly in psychology, to say that guidelines are just advisory, aspirational. However, from the attorney's perspective, we take a different perspective, don't we? We don't really care whether they're going to take the expert out and shoot him or her when they go back and deal with their professional guild. What we're looking for is evidence of a standard of practice, and certainly guidelines reflect that. It's a problem that's often been difficult to work out, but if we want to know what it is that the experts in these various disciplines are being told, perhaps in some cases required to do when it comes to these matters, the one that is absolutely on point with competency to stand trial, competence to proceed, is AAPL, the American Academy of Psychiatry and the Law. They published practice guidelines for forensic psychiatric evaluation of competence to stand trial. You can go directly to that. How hard is it to get? It's not like one of these proprietary things. You know how you're always told with the test data, I can show them to you, but then I'd have to kill you. Apparently, psychological tests are only to be approached at certain times of day cautiously, like some cranky professors, and you can look at them, but you can't touch them. And because the idea makes sense is that we don't want them to just be out there for everybody to be able to examine in advance, because then how valid a test is it? But when it comes to these guidelines, they're just available on the internet. All you have to do is Google American Academy of Psychiatry and the Law, and all of these issues come up. On the other hand, if you have difficulty with that, if you don't have a computer, but you want to borrow somebody else's for me to send you, I'd be glad to send you a copy of those guidelines. There are ethical principles of psychologists and code of conduct. These are the enforceable ones for psychology. They're general in nature because back before the last version, they took out all the things that apply specifically to forensic psychology. It appears here and there, but there are specialty guidelines, aspirational, non-enforceable from the professional's point of view, for forensic psychology. Website for that, and also for the American Academy of Psychiatry and the Law, which is the forensic specialty outfit for the psychiatrists. We have ethics guidelines, very physician-like, right? 5 pages to the point. What it took the psychologists 16 pages to say, the physicians just get right in there. When your profession is about whether or not somebody's going to die, you learn to get right to the point. And then Virginia is for lovers. I thought this was goofy when it came out 40 years ago, but they stuck to the brand. It's worked for them. They have lawyers too. When Ohio wanted to do Ohio is for hookups, they shut it right down. This is our bailiwick. I mentioned Virginia, and we will hit our break right on time, because Virginia actually has standards at the state level like nowhere else I've ever seen that tells you what is or is not supposed to be in a competency report, and it has a panel of people who actually review redacted versions of every competency to stand trial and criminal responsibility report developed for courts in that state to see if they meet the standard. You can think of the implications of that, but you can think of them on the break. I have 10 o'clock cardinal sin to run over. I'll see you after the break. Of grunting and blinking as I moved my finger to the next potential letter. Actually, his intellectual functioning was just fine, and we were able to determine also that he was being abused by a caretaker. So The doctors will go in and do what they need to do. They don't need to pile on. They don't need to pad their evaluations, but they need to look at these different issues. There is cognitive testing. There is personality testing, by which we don't just mean personality, by which we also are referring, in this industry term, to things that are not cognitive. It could be a question of a psychotic illness. Here you see something that's kind of like an ink blot, a projective test where you show somebody something and say, what does this look like? There are also what they call objective tests, and that doesn't mean that we find them objectionable or that you're compelled to object, but it's objective because you don't have that much trouble interpreting the answer. True, false, yes, no. Those things we can run through computers and come up with a number of scales that look at different issues in personality or in psychosis, because we talked about whether you're smart enough to be competent, but there's also the question about whether or not you are capable of holding yourself together psychiatrically enough to grasp the nature and consequences of these proceedings and to participate rationally in your own defense. Absolutely no disagreements with Chris on these ideas about what it means for counsel and what the reflections are. When we talk about Chris's Jesus Christ 2000 case, I had a similar case. It didn't have the same religious significance, of course, as his case, but it did have political significance. I went to see a guy in the local jail, and he knew it all. Back and forth about what judges do and what everybody does and what the potential sentence is. But eventually we got to the point where he explained to me that it didn't really matter because he was going to get a pardon from President Clinton. Well, those of you who remember those halcyon turn-of-the-century days, remember there were a lot of pardons being handed out, but it wasn't this guy for his local criminal offense. But again, if you think that it all doesn't matter, it doesn't wind up mattering how knowledgeable you actually are. This guy also thought that the judge was materializing through the walls of his cell and coming to visit him at night. That was as easily disproven as the Clinton thing. It turns out that wasn't true at all. This guy wound up being found incompetent to proceed. There's also testing for malingering. We're going to have a criminal justice section podcast on malingering. We don't have time to get into that today, but I want to say that there are a number of tests out there on malingering. Unfortunately, a lot of them can be found on the internet, which kind of undercuts the whole notion of a malingering test. But in general, our colleagues at the bar often don't quite get malingering. You know, it's not what they do. Malingering is not a catch-all for every single thing that you might say that isn't true. Sometimes people are responding randomly to the tests. That's just poor effort, not pretending to have a disability that you don't have. Sometimes people are actually trying to mask an illness because they have certain things they want to achieve and they don't want counsel to be able to interfere. You get all sorts of different things under this broad heading, the mouthful of dissimulation. But there are malingering tests. You should look askance at any trial competency evaluation that does not have some test for malingering, that does not contain some measure of effort because of what we call secondary gain that could accrue to the defendant if he or she winds up being found incompetent to stay in trial. It's not that they all do, but this needs to be a part of the testing. So you've got your testing for intelligence and the like, you have your testing for your psychiatric status, and then there is forensic testing. You remember this notion of, well, is that really a competency test? There are competency tests. They don't need to be conducted instead of your standard clinical testing, and indeed it's your clinical testing that will often be able to let you know whether somebody's capable of turning in a valid performance on the forensic test. But the forensic test, for better or for worse, is something that goes right at the issue. As a general matter, one of the problems with forensic testing is that some of our standards are jurisdiction specific. Look at New Hampshire, for example, which has this notion about being able to, quote, assist counsel. It contemplates somewhat more of an active role than maybe is done in some other jurisdictions. Also, Chris referred, and rightly so, to the complex issue of ultimate issue and how that plays out different ways. I share Chris's concerns about how exactly we put that across. But sometimes as experts, it's out of our hands in a competency matter. Kentucky, for example, says that the evaluator will state whether the individual is competent to stand trial, and then will state some other things having to do with restoration, as we'll see. So what are some of these tests? Now, again, in the interest of what they call test security, what I'm going to give you is some examples of the kind of questions that would be on the tests so that we're not actually blowing the test here. The grandparent of them all, there were a couple that were out there that were more obscure, but the one that really got us rolling on forensic testing is the aptly titled competency screening test. Almost 50 years old now. It came out of the Harvard community psychiatry movement in the early 70s. Here is actually the introduction. Here are some incomplete sentences dealing with courtroom situations, and that's classic old school psych testing. Incomplete sentences. It still has this kind of psychodynamic thing to it. You know, what does the defendant think? What can they supply us? Each one has something to do with the law and going to court. There are no right or wrong answers. Really? Okay. I mean, here we are. So yes, of course there are right or wrong answers. That's not really what they meant by it. I think they're not saying they're saying there's not really one right answer. Your first impression is usually the best. Well, okay. And again, competency evaluation, right? One of us is wearing orange. It isn't me. Your first impression might not actually be the best, but it's encouraging in the best. You know, it came out of Harvard, not the Ninth Circuit, but still it is upbeat and positive. And Chris and I did not conspire to pick on the, what is it, the Golden, what is the California, the Golden State, is that it?
Yeah.
It's really nice out there, it really is. It may not be for lovers. It's, you want to go there. If for any reason you cannot complete a sentence, now, there are 3 potential meanings to that. Some of these people actually can't complete a sentence, but that's not what they mean. Some of these people might not be able to last in prison for 5 years. That's not what they mean. What they mean is, if you can't come up with something, then please circle the number and go on to the next one. If you're not even capable of circling a number, that probably tells us something too. But there are these kind of questions like this. The lawyer told Bill that blank. The way a court trial is decided, blank. If Jack had to try his own case, why is this all male? To reflect the fact that the test was back in the day. Notions of inclusiveness were decades ahead from when this test was being made. And a good answer, a 2-point answer, might be the lawyer told Bill that he was ready to review his motion of discovery. All right, that doesn't tell us everything about being competent, but it's focused, it's on track. The lawyer told Bill that, and he believed him. Okay, a little off-center there, maybe a 1-point answer. Oh, it's nice that he believed it, but does it really tell us anything about competence? The lawyer told Bill that the judge, as a Martian, would be visiting other planets and the trial would be postponed. Not to make fun of Mars, but this is not a good answer. This is the sort of thing that would be thought of as reflecting some kind of delusional process. This is a nice, as it says after all, screening measure. No one test on any topic tells you everything you need to know about an issue. This test is still out there today. You can see from whichever side of the aisle you're handling this case, some of the positives and negatives to this sort of thing. Again, if you have an expert who only used this, didn't bother to do anything else, and said, no, I nailed it with one of these forensic tests, if they're your expert, you've got a lengthy discussion ahead of you, which the expert doesn't mind. He or she's getting paid by the hour. The competency to stand trial assessment instrument came out around the same time. And the thing about the competency to stand trial assessment instrument is that although it's kind of a stretch to call it a test, is helpful because what it is, as so many of these forensic measures are, a way of looking at this information comprehensively. There were some sample questions. They were terrible sample questions. They were leading. They had all sorts of issues. But they want you to look at these different things just as you would follow up in an interview. And as you go down the list here, you see all of the different things that Chris was describing. What kind of defenses do you have? How are you supposed to behave? And then here's the rest of the list: appreciation of range and nature of possible penalties, all of these different things. This is the kind of stuff that you want to know. And it's helpful to have a measure like this, again, pushing it to call it a test, but to help keep the expert focused. Is it necessary? No. If he or she conducts the other testing and does a properly conducted forensic interview, then that's going to be fine. And although you won't be able to see it much, even those much younger than I am, again, we'll send you stuff if you like it. But the reason for putting that up there to show you is that you got all these different issues, and then you have a scoring system from 1 to 6. Those scores are kind of pretty loose. Sometimes assigning numbers to things isn't that helpful, but it helps keep people focused. There's some other examples. The competence assessment for standing trial for defendants with mental retardation, or as we now call it, intellectual disability. Any humor that may seep through this portion is, I hope needless to say, not at the expense of persons with intellectual disability. This was a noble effort on the part of a psychologist attorney team. Now, if you don't mind identifying yourselves, even today it's okay to admit it, any public defenders or other defense attorneys in the room? Quite a few, right? Now, how thrilled are you with the idea that your client might not pass the normal competency test, so we should give him or her another test that is easier and that sort of runs against the whole thing that you're trying to establish, right? I hear that from defense attorneys all the time, and I cannot disagree. I'm certainly not here to wave the flag for these measures. Another thing about this test, the CAST-MR, is that it is largely multiple choice, which brings up some other issues. Also, there are some issues about the content, and if you're defense counsel, what you're going to argue is, well, wait a minute. I don't care that they got 48 out of 50 on this. Look at the two questions they missed. What does a judge do, and what does a prosecutor do? This is kind of important stuff, and trial competency is a binary matter. At the end of the day, the judge is going to find that this person is or is not competent to proceed. So, counsel on both sides of the aisle, if you can get copies of stuff, you're going to want to try to get it. We talked before about how hard it can be to get test data, but at very least, you're going to want your expert in a serious matter, and what matters aren't serious for the defendants or for the state, to review this stuff and see what answers there actually were and see what sorts of things are going on. Test scores themselves are not necessarily going to give us the whole picture. There's also a MacArthur competence assessment tool for criminal adjudication. It is based off of a single simple assault fact pattern, which I fabricated here because we're not going to use the real one. The MacCat CA. Phil and Roy are playing cards in their dorm room, drinking a 6-pack of beer. Phil makes a rude comment about Roy's girlfriend, and Roy throws a beer bottle at Phil. Kind of takes you back, right? Those college days. Phil collapses with a serious cut over his left eye. Roy finishes their remaining 3 bottles of beer. Defense counsel are going, great, thanks. And then calls an ambulance. Well, at least he called an ambulance. And now defense counsel wants to argue that his substance abuse problem kept him from, he was in withdrawal. This is what steadied him to be able to make the call he so desperately wanted to make. You can make all sorts of arguments on behalf of Roy, and if you are the Commonwealth, the state, the people, the government, you may take a somewhat more jaundiced view of Roy's behavior. But here's the fact pattern, and from that fact pattern, in a rather wordy way, the test goes on to ask questions and get answers from the defendant about what this all means and how they would deal with it. One of the arguments against such a test is, okay, kind of specific to simple assault. Does it, as Chris ably pointed out, grasp the complexity of some of the other issues that are going to be faced, say, in a capital murder case? Does the whole college milieu in this example really comport with the life experience of the individual being tested? The actual fact pattern makes some other, if not assumptions, at least kind of puts you in a specific kind of situation, the actual fact pattern. Certainly, again, an attempt on the part of the psychologists and everybody to do something. And again, although you can't see it that well up here, it scrupulously avoids the ultimate issue. This is the direction the winds were blowing at the time. It looks at understanding, it looks at reasoning, it looks at appreciation, and describes impairment from clinically significant impairment all the way down to minimal or no impairment in terms of those domains, what people understand, how they reason, and how they appreciate. So it will not give you a bottom line competence to proceed score, but is used to be helpful. I would say in regard to all of these forensic tests that while they yield useful information, it's not the whole ball of wax. Again, if you see a report that simply has one of these tests and nothing else, you know what to do. Assessment modalities also include interviewing. This is when you actually sit down. If you get a report that's just about tests and no interviewing, there are concerns, and looks at competency. And there are structured interviews that are basically these decision trees in a lot of cases, telling you what questions to ask, and okay, if they say this, then that, if they say that, then something else, in order to help you arrive at the right diagnosis. Diagnosis can be a part of it, but these are things that basically tell the doctor what sorts of questions to ask. However, there is also the boots on the ground notion of what eventually has to happen, which is thank you for the testing and the patterns and everything else, the discussion about those issues that we reviewed and that Chris has pointed out about what's actually going on with the individual in his or her specific case. This is an indispensable part of a properly conducted and optimally filed and championed or derided competence to proceed evaluation. Those are two of the components that we're seeking. But one more thing about the interview thing before we go on to records. There's real controversy, as there should be in the field, about the notion of coaching. And by that I don't mean what you might think and what you often hear, counsel coaching his or her client how to take the test. That's not a good thing, but that's not what we're talking about here. What we're talking about is coaching on the part of the evaluator. And the reason this comes up is that when you look at prospects for restoration, you need a little air up here. All the hot air is coming from the front of the room. When you're looking at the prospects for restoration, when you're looking to see if somebody is maybe competent but just ill-informed, do you want to get a sense of what they know? Sometimes, however, and they taught me to be competent is the title of a presentation that we did at a state conference a while ago. Are they just handing them the answers and saying they're competent? And I have seen it literally as bad as the following. You don't know what a judge is? Well, the judge, that's the person wearing the black robe sitting up at the front of the room, and they're the ones who are going to decide if you're competent. And if you're guilty, they're going to sentence you. Would you accept that? I mean, does that make sense to you? Client, sure. Now, is client getting it? Maybe. Is client just basically acceding to the power of whoever it is that's making the suggestions? That doesn't bode too well for a number of things, including rational participation in his or her own defense. What's really going on there? It's a problem, especially when the conclusion is, well, that person's competent. You see these sort of warning signs and reports. After education, upon further discussion, was willing to accept that. Sometimes it's that blatant. Defense counsel in particular, and the prosecution, because they want to get it right, need to be very on guard about the idea that teaching, that coaching has been going on in the evaluation. And sometimes, and this isn't to make fun of the doctors who are doing it, they'll say, and I revisited this with them after 15 minutes, and they had retained the information. That's pretty cool, especially, bless you, especially if they are waiting to have the trial right outside the door from where you're doing the evaluation. And you know what? Sometimes that happens. Sometimes it's like one-stop shopping, right? You got the doctor here, the courtroom there, out in back of the courthouse, someone's stretching a rope. We're going to do the whole thing in one go and save some money for the taxpayers. But if you're defense counsel, naturally you are going to want, in the course of these things, as a couple of months go by, and I'm not talking about delaying the case or playing any games, but these things can take a lot of time. You send your expert out to the jail and see if, in fact, this stuff actually stuck in the terms that were described. Maybe it did, great, person gets their day in court. Maybe it didn't. Prosecution, again, has an equal investment in the truth and is also going to want to be alert to these issues. All right, what about record review? Record, yes, ma'am.
Our jurisdiction here in New York allows both the prosecution and the defense to be in the interviews. I mean, as a mental health person, what do you think about those kinds of, the change that might actually engender having the attorneys in the room?
Changes for good from some points of view, changes for bad from others. One of the things that defense counsel tell me is one of their waking nightmares, and they have many, is that the client will blurt something out that may or may not have anything to do with competency. Then how do we cure that? There is also a movement largely propounded by neuropsychologists, some of my best friends, and that's not a joke, who are really concerned about the whole notion of third-party observers and what that means for the way that somebody's responding. You can understand the reticence of a competent or not so competent client in responding to some of these questions with the government sitting right there. But let's not just focus on negatives. How about openness? How about everybody getting to know what's going on? A bunch of these other things. Some jurisdictions sort of have part of that. Again, I'll use a Kentucky example. Kentucky provides for the presence of the other side's expert in the room during the evaluation, which also helps to cure some of these test security issues. The Kentucky Supreme Court threw out the notion that this meant that counsel was entitled to be there. But to use New Hampshire again as another example, two very similar states in a lot of ways in terms of their terrain and surprisingly in country music. When Montgomery Gentry went up to New Hampshire, they reported back excitedly to CMT, there's rednecks everywhere. And it's true, there really are. And unless you think otherwise, I love this music.
So if you were doing,
Okay.
do you want, if you were doing this forensic interview, do you want the attorneys in there?
For one reason in particular, it can be a good idea. And thank you for reminding me to bring this up. When it comes to rational participation in your own defense, it's really nice to see if they're not getting it, if not the doctor, but counsel can talk them some sense into them. It's a very powerful thing to be able to report, or not to be able to report, because you're not skewing it, as to whether or not counsel was able to tell them what it is that the judge does and whether they seem to get it. Pros and cons. I want to say briefly about record review two things. First of all, there is a spoliation frenzy going on in the United States, and it has to do with the schools. Everybody here went to school. We're not knocking schools. I suppose there are a couple states where you can just waive in, but I bet everybody went to school. And it used to be, those of you who've been around for a while practicing capital cases, there was always this point where you go way out in the country into the basement of this schoolhouse and you pull out the moldy collection of tests and blow the dust off to them and look at these things like the Otis Lennon test of mental abilities from the 60s, and you try to figure out what it all means. Much less likely today, because schools are sick and tired of people like me coming under the directions of counsel or the court demanding stuff. Nowadays, you have to hire somebody at a school full-time to stand in front of the copy machine, endlessly cranking out materials. And even the rise of the digital age hasn't made it much better. It's harder and harder to get records, but the expert witness working for either side of the aisle should stand prepared to review anything. And when they're asked by counsel, what do you want to review? Counsel, whatever you're willing to send me, because that's what you're going to want to be able to talk about when it comes to cross-examination. There are many sources. Won't surprise anybody in the room. Clinical, medical, educational, their work history, institutional or agency records, military records, legal records that are shareable and don't run afoul of the very difficult issues of attorney-client privilege, especially when investigators and expert witnesses are involved. Let us take some time to look at restoration as promised. This is one of the most, to use the technical term, messed up aspects of trial competency practice today. because a lot of times people really don't get it. First of all, it's arguably a misnomer in some cases because the very term restoration suggests that somebody was capable of doing these dusky type things, but now isn't, and we can bring them back. I'm sure we'd all agree that there are some folks who never had it in the first place. Many of you, prosecutors, defense attorneys, have experienced cases in which the judge will say something like the following. We'll just make it a she. She's not competent, but here's what we're going to do. Counsel, I'm going to ask you, I know you're busy, to really spend some time getting with your client, going over this information and explaining it to them. That's not lack of competency to proceed. That's a lack of information. That's a lack of face time with counsel. Is that some implicit criticism of counsel? Not at all. It's just that it's not trial competency. One thing that they tried to do at the University of New Hampshire School of Law, where I teach, they came to me because they had a great idea. You know what we're going to do? We're going to get 2 L's and 3 L's to sit with these incompetent clients, and we're going to have competency camp, and we're going to explain to these defendants all about the law. It's the same difference. The point of competency restoration is that it relies upon something that counsel, with all the time in the world at his or her disposal, would not be able to provide. That is psychoeducational counseling that is a combination of the clinical treatment, medication if necessary, the ability, the psycho part, to work with and teach to them at a level that they can understand, helping them to bind their anxiety, to use the old-fashioned term, along the way, and providing the educational component. Do we need to helicopter these folks out to the special competency restoration unit at the Mayo Clinic? No. It's a good thing since it doesn't exist. This is the sort of thing that a properly briefed, not to patronize these people, but as an example of how widespread the help is, a community mental health professional at one of these agencies, in the case of the, as most of them are, indigent defendant in a competency matter, certainly not all, but most, if they know the legal issues, if they're competent to treat the underlying condition, that's where you might want to go. What so often happens is that defense counsel runs into an interesting situation. The judge says, all right, I'm willing to find this person incompetent if, okay, we get problems right away, right? But I'm willing to find this person incompetent if you go ahead and arrange the competency restoration treatment. Yeah, because defense counsel has every reason in the world to spend some additional effort trying to make his or her client competent. And I've seen defense counsel turn it back on that basis and say, no, we're not gonna do this. But then, on the other hand, you take the old Hemingway quote about, I've noticed that doctors who fail in the practice of medicine have a tendency to seek one another's company, and it talks about the fact that there are bad doctors out there. It's an ethically fraught notion, but after all, aren't you just fine with being the one that picks the lowest common denominator doctor who isn't going to, quote, make your client competent? I'm not making any recommendations there, and I'm not trying to lead people down an ethically challenged path, but there are those factors concerned in terms of how you might participate. All of this to the confusion of the judge. We're not making fun of judges either, but competency restoration as a notion across the country is typically very much in flux in terms of understanding procedure and resources. We are right up against the end of my time. Thank goodness for you, I will just mention some general concerns. Out-of-date tests, people who conduct evaluations without actually seeing the defendant, students doing the evaluations, no, not good. A lack of fit, meaning giving people tests that are not suited to them culturally or in other ways, leaping to a diagnosis without the proper substantiation, crouching from diagnosis without the proper review of materials, and experts coming from out of state when they're not licensed to be there. Got to be careful about that. And let me hand it back to Chris.
Wow, okay. Great pictures. I wish I had pictures.
You can backspace and use some.
Yeah, okay. I like that one with the 3 legs. I got to use that somehow. Pretty cool. Okay, so I'm just going to spend about 10 minutes going over some last legal issues, and then we're going to open it up for questions. Hopefully there are a lot of questions, and if not, we know how to fill time. So let's assume an evaluation has been done of competency, and the report's been submitted to the parties. Now what happens? And what I want to do is ask 7 or 8 questions, many of which were suggested by Mr. Melson for us to answer, and then I will quickly go through how the ABA answers all those questions. So the first question is, assuming we're going to have a hearing, when does it take place? You have here the answers given generally across jurisdictions and the answer given by the ABA. Of course, many times there is no hearing. Those of you who are in the area know this. Probably 80 to 90% of the time there is no hearing. The parties stipulate as to the person being competent or incompetent. The ABA takes a very strong position on the following issue. That is, if a person is found to be incompetent, there's not necessarily a need to go ahead with the restoration process, so-called restoration process that Eric was talking about. Instead, charges can be dismissed or dismissed conditionally, and the ABA standards strongly recommend this, especially with respect to misdemeanors, but also even with respect to lower-level felonies. A number of states are starting to do this. There's no reason to keep a lot of these people in the criminal justice system when the main concern is their treatment. If they're treated, the idea being that they probably won't commit any further crimes, or at least they'll stay out of trouble much better than were they not treated. So that's an aspect of the ABA standards I want to emphasize. There is this idea under 4.8E that people be diverted out of the system early and often. Another question, second question, which side has the burden of proof? The United States Supreme Court has held it's permissible to put the burden on the side asserting incompetency. You have the site there, and the ABA agrees and says that standard of proof should be by preponderance of the evidence. And the idea here is that we ought to make it hard to show incompetence. Ought to be a presumption of competence, as a matter of fact, because incompetence is stigmatizing. We want to put a thumb on the scale of the finding of competence, in part because of the stigma, and in part because we're going to assume most people have the wherewithal to engage in the criminal process. A third question, when can the content of the report, the competence report that is, and the hearing transcript of the competency decision be used at trial or at sentencing? So we got the competency report and competency hearing. That's, of course, pretrial. When, if ever, can that evaluation result and what happened in the hearing be used at trial or at sentencing? There's a famous case, Estelle versus Smith. How many people know about Estelle versus Smith, just out of curiosity? In which a Dr. Gregson, who famously came to be known as Dr. Death because he testified in over 120 capital sentencing proceedings in the state of Texas, he purported to be able to address a person's competence and insanity and dangerousness for purposes of capital sentencing based on a 30-minute interview. And the results of his competence evaluation were therefore used not just for competence, but also to address insanity at trial and address dangerousness at sentencing. What the Supreme Court said in this case of Estelle versus Smith, which is the case I just referenced, is that a competency evaluation the results of a competency evaluation should only be used to address the issue of competency. Should not be used to address any other issue at trial or at sentencing unless and until the defense decides to use the results of that report at trial or sentencing. In other words, the defendant controls, the defense controls the use of the report. Otherwise, it's only used to address competence. And this is true, the court strongly suggested, even if the evaluator gives some semblance of Miranda warnings during the competency evaluation. That is, anything you say may be used against you, which implies could be used against you at trial or at sentencing. Doesn't matter. It still can only be used on competency unless and until the defendant decides to use it for some other purpose. And most states now have statutes or rules that specifically provide for what I'm talking about. However, the Supreme Court's also held that if the defense does open the door to use a competency report, the prosecution can use the results for any purpose for any mental state purpose for which the defendant raises an issue. So, for instance, in the Cheever case, the defendant raised an intoxication defense, which is only tangentially related to mental disability, but nonetheless, the Supreme Court said that's enough of a door opening to allow the results of a competency evaluation to be used. So the bottom line here is the defense controls it, but watch out, defense. You open the door in any way, shape, or form, and it's constitutional to use the results of the report for other purposes. Another question, when can the decision at the hearing be appealed? Well, this is actually a question that's answered differently in many different jurisdictions, but it appears to be the case that it's permissible and often the practice to allow a finding of incompetency by a trial judge to be appealed on an interlocutory basis. That is, before you get to trial, because of course if the person is incompetent, we shouldn't have the trial go forward. And if the person is convicted and later has turned out he is incompetent, was incompetent during trial, then there's been a waste of resources. And the Supreme Court decision in Sell seemed to suggest that is the case. Sell actually involved forcible medication, but there the United States Supreme Court specifically held it was okay to appeal whether forcible medication to restore someone to competence was permissible on an interlocutory basis. So my guess is the same would be true with respect to an appeal of the competency issue generally. So another question, and of course it derives directly from what I just got through talking about. When can a defendant be forcibly medicated to restore competence? I'm using the word restore even though I agree with Eric. Restore might not be exactly the right word just because this is the word you see in the court's cases. And the issue here, of course, is that most of the time, if a person is incompetent because of severe mental illness, medication is going to be the mechanism for restoring the person to competence. Not always. Cognitive behavior therapy, some other kinds of techniques might be ways of restoring a person to competence, but medication is often going to be the way. And some research shows this, as often as 75% of the time, defendants refuse medication at some point in the process. So we have medication being the only way to restore and lots of refusals. So can the state force medication on individuals in this situation? These medications are very powerful. They can have very strong side effects. In Riggins versus Nevada, the court displayed that it was sensitive to the side effects of these medication. Riggins was medicated with 800 milligrams of Meloril, which is an antipsychotic medication, and his capital sentencing proceeding, he was pretty much comatose throughout most of it because of the medication. Because these medications not only remove delusions and hallucinations, they remove a lot of the rest of a person's cognitive function as well if they're not titrated correctly. And apparently that's what happened with Riggins. So what did the Supreme Court say? That if you're going to forcibly medicate to restore someone to competence, have to make sure of several things. First of all, the medication is medically appropriate, meaning that there are not serious side effects, and the medication actually addresses the underlying medical problem. And then secondly, that it is effective. For instance, there have been several cases where there has to have been expert testimony making clear that the medication actually will work. It often does not work with some people with schizophrenia, especially people on whom it's been tried before. If we know, in fact, it doesn't work, then arguably the medication is not the way to go with respect to restoring competence. It also, the court said, has to be the least restrictive way of restoring competence. There are, as I just mentioned, other ways of restoring competence. Medication might not be the least restrictive way of doing it because of the side effects. And finally, the court said, got to make sure that if you do medicate, it does not impair a person's Sixth Amendment right to confront accusers. Riggins was a perfect example of this situation. Yes, it removed the delusions, but it also undermined his ability to communicate with his attorney, therefore undermined his Sixth Amendment rights. So the lesson of Riggins is you got to have medically appropriate medication that's titrated exactly right, that gets rid of the problems that are causing the incompetency, but at the same time doesn't overdo it, doesn't make it difficult or impossible for the person to communicate with the attorney. Then we get the Sell case, which scared the hell out of a lot of forensic mental health professionals because there was language in Sell, written by Justice Breyer, which said constitutionally permissible forcible medication may be rare. That's a direct quote, may be rare. Well, mental health professionals were used to forcibly medicating people who needed to be restored to competency with antipsychotic medication. And here's the Supreme Court coming along and saying, oh, this may be rarely permissible. That was the language. That was why mental health professionals were worried after Sell that they would no longer be able to restore many severely mentally ill people to competence. It turns out, though, if you read Sell closely, there are 3 exceptions to the idea you cannot forcibly medicate, which basically blow a huge hole into the idea that you may not forcibly medicate. I call them the baby bear, mama bear, and papa bear exceptions. The baby bear exception, which is still a pretty big exception, is if we're talking about a serious offense, the Supreme Court in Sell said it's okay to forcibly medicate. And lower courts have basically said if the maximum sentence is 10 years or more, then you can forcibly medicate so long as Riggins is met. It's important to remember Riggins always has to be met. It has to be medically appropriate, effective, least restrictive, and it doesn't impair Sixth Amendment rights. But assuming those criteria are met and it's a serious offense, you may forcibly medicate. That's the baby bear exception. The mama bear exception, and you can also forcibly medicate if the person is dangerous to self or others. Well, that's a pretty big exception. We got a guy charged with a serious offense. It's very possible they're dangerous to others, or if not, maybe they're suicidal. Maybe they're dangerous to self. And then we get the huge exception, the Papa Bear exception. Even if those other two exceptions don't apply, if the person's incompetent to make treatment decisions, it's also permissible to forcibly medicate. This is standard tort law, right? If a person is incompetent to make treatment decisions, then someone else can make the decision for them. Well, think about it, the Venn diagram. It is true that just because you're incompetent to stand trial, which is what we're talking about here, right? People incompetent to proceed. You may not be incompetent to make treatment decisions. The two Venn diagrams overlap significantly. If you're incompetent to proceed, you're probably also incompetent to make treatment decisions, which is why I call this the Papa Bear exception. Basically, these three exceptions mean you can almost always forcibly medicate someone if you want to. And people have come to realize that post-cell. For about 5 months, people were freaking, but now they understand, no, it's still permissible to forcibly medicate. I'm not saying we should forcibly medicate. Riggins is still very important because these medications are very powerful. But if Riggins is met, then usually you'll probably be able to forcibly medicate over a person's objection. One other point with respect to medication, which is really important, it's very common. I always find this to be true in every jurisdiction I talk. A person's medicated in the hospital, restored to competency, whether forcibly or not. This may not be forcibly. It may be voluntarily. The person's medicated, restored to competence, then sent back to the jurisdiction for trial, and what happens in jail? They decompensate. The jail won't treat, either because they don't have the appropriate staff, it's too expensive, they're worried about liability, there are all sorts of reasons. This is a major problem. And what happens, of course, then the person's sent back to the hospital. There's one case in Florida which ended up costing the state of Florida $1.3 million. The guy was sent back and forth 7 times. So incredibly ineffective, stupid, and very harmful to the defendant. Every decompensation causes more and more mental suffering and makes it harder and harder to restore competence. So what the ABA standards provide, and the standard you see here, is there should be a provision allowing a local court to require maintenance of treatment in order to keep the person competent. Ideally, a trial would take place immediately, but we all know that doesn't always happen. So ideally, and in fact, the ABA mandates this, or at least recommends it, there be provision for allowing medication to be maintained. I think this is the last question. How long may the state detain a person found incompetent? Let's say a person is found incompetent, they're sent to a hospital, or maybe treated outpatient, but normally sent to a hospital, and the restoration process is not going all that well. The guy doesn't seem to be coming around, whether it's through medication, cognitive therapy, or some other treatment mechanism. The key case here is Jackson versus Indiana. Some of you have probably heard of it. This was a case involving a person who was deaf-mute, stole 2 different purses, had 2 charges of petty theft for a total of $9, was found incompetent on those 2 minor charges, sent to a state hospital in Indiana to be restored. 3 years later, a defense attorney found him in the back wards of the hospital and brought the case that became Jackson versus Indiana. And what the Supreme Court said per Justice Blackmun is that's outrageous. Okay, you shouldn't be able to keep a person, especially with those kinds of charges, in a hospital indefinitely, maybe for the rest of his life, just because you can't manage to restore him to competence. So what Jackson said under the Due Process Clause and Equal Protection Clauses, as you see here, the state may confine those found incompetent only for a reasonable period of time necessary to restore or determine unrestorability. Then the state only has 2 options. If you can't restore him within a reasonable period of time, you either have to civilly commit him or release him. Civil commitment or release, that's it. Those are the only 2 options. The ABA endorses Jackson rigorously and says if you can't do it within a year, you're done. In the year, you have to take steps, either civil commit or release. Okay? Now, unfortunately, many states, in fact, most states, don't pay attention either to Jackson or the ABA. And what they do is they keep people way beyond a year. I teach mental health professionals, I always ask, if you're working in a hospital, how many of you know of a person who's been found incompetent and is there 2 years later, 5 years later, 10 years later? I get tons of hands. What's going on here? The people are charged with serious offenses. And in fairness to the system, the judges and prosecutors and even defense attorneys don't feel good about releasing a person charged with that kind of a serious offense or civilly committing that kind of person because of the seriousness of the offense. Too bad. Jackson versus Indiana holds as a constitutional matter, you have to release or civilly commit them. There's no other option, okay? And I always encourage defense attorneys to bring class actions on behalf of all the people who are in these hospitals, eroding away, decompensating. Get a class action suit on these people's behalf to get them out of the hospital. This is going on, by the way, in Philadelphia and a couple of other jurisdictions now, and it should be going on all over the country because it's unconstitutional to keep these people in for a long period of time. What the ABA does is say that after a year, actually this is not in the slide, but it should be, after a year, the state either has to release the person or civilly commit the individual, but as a bow to the idea that we have to worry about public safety and public perceptions, it's okay if you civilly commit the person, it's okay to commit them to a forensic unit, that is a higher security unit, than just a simple civil hospital. So that's how the ABA deals with the situation. Oh, sorry, one last question. I lied. Maybe there are two more, actually. May a defendant be taken off medication to demonstrate the unmedicated state? You asked this question, which I think is an interesting one. You're an attorney. You're asserting the insanity defense. You want your client to look, sorry for the word, but you want your client to look crazy in front of the jury. You're afraid that if the person's on medication, they won't look crazy. In fact, they'll look the opposite of crazy. And that's not good for your defense. So can you take the person off medication so that the jury can see what the individual's like in an unmedicated state? Answer, no, can't do it. There was one Supreme Court Supreme Court case out of Vermont which held it is permissible to do that. Under certain conditions, you take the person off for exactly the time period they were off medication before the offense. And you make sure that before you take them off medication, while competent, they agree to be taken off medication before you take them off. Interesting solution. Huge problems from a number of different perspectives. First of all, just because he was off his medication for 3 weeks before the offense doesn't mean if you take him off 3 weeks before trial, you'll replicate the mental state. In fact, it's very iffy that you'll be able to do that. Secondly, it's probably unethical for a mental professional to take someone off medication after they've been restored. And thirdly, just because a person says, while competent, I'm willing to go off medication, doesn't mean at the time of trial, in the middle of trial, the person might not change their mind. Were they competent enough to understand what's happening during trial? So other than Vermont, no other state does this. ABA certainly doesn't recommend it. Final question, may the defense use an incompetence fine? Oh, but by the way, what you can do, you can show a video of the person off medication if you have one left over from close to the time of the offense. You can also have an expert describe what the person was like off medication and so on. So it's not like you're defenseless in this situation. Finally, may the defense use an incompetence finding to support mitigation? In other words, the person is found incompetent to stand trial. Now we're at sentencing. Can the incompetence finding be used at sentencing? Well, there's the Estelle versus Smith problem, remember? Unless the defense decides to use the evidence from competence, it can't be used at sentencing. But this is assuming the defense has opened the door. Now the question is whether or not it's relevant. Is finding about competence relevant at sentencing? The argument that it's not relevant is competence is about present mental state. Mitigation is about mental state at the time of the offense. So you can argue it's not really relevant to prove incompetence for purposes of supporting mitigation. The only thing I'll say here, and then I'm going to stop, is well, in Jones versus United States, on the other hand, the Supreme Court said you can presume mental illness post-trial from the fact a person asserted an insanity defense. And if the Supreme Court says you can presume mental illness now from the fact that a person asserted an insanity defense with respect to mental state at the time of the offense at trial, then presumably you can argue incompetence now is relevant to mitigation, relevant to mental state at the time of the offense. So I think I'll stop there and see if there are any questions.
Just a quick thing to add on there, this notion of using incompetence to pile on in mitigation. There's sort of a what's good for the goose is good for the gander argument when you think about Wainwright versus Greenfield. Folks remember that case? They pick a guy up in the park and he avails himself of his Miranda rights, and then the prosecution tries to argue later that this was evidence that he was criminally responsible because he was able to understand and refuse to talk to the police and invoked those rights. And the Supreme Court of the United States says, no, we're not going to penalize people for going along with Miranda and then find them to be criminally responsible on that basis. So it's kind of an inversion of that argument. I apologize for whatever good question we didn't get to hear because of that.
All right, so I have a question. The trend now is not to use the term to a reasonable degree of scientific certainty. How do you express your confidence in your opinion if you don't use that phrase, or do you use that phrase despite the direction of the Department of Justice?
It's, Chris?
It's a meaningless phrase.
Yes.
Okay.
Thank
so
you, Doctor.
How do you express it?
Well, what we do is we have them ask us. We did a study, and we established that expert witnesses don't understand what that phrase means and find more meaning in other phrases. Article after article in the Journal of the Academy, the American Academy of Psychiatry and the Law, and other sources have gone on about the fact that it is an empty notion. But if the court asks us, then we can answer. You know, doctor, do you hold these assertions to a reasonable degree of, now sometimes they'll ask me medical certainty, and then I can say, I'm sorry, I teach in a medical school, not a real doctor. So you have those sorts of issues. But expert witnesses should only proffer that if they're required to do so. Bless you.
Jonathan.
I had a question. It's two parts. I know anytime you go to develop or revise standards or guidelines, you probably identify research areas where there's gaps in understanding. And I was wondering if there's certain things in the development or revision of the standards where you said, hey, here's like the top 5 research areas. We really wish we had more information. And the second part of that question is
ABA standards, ones I've been talking about.
yeah, or just in general for competency determinations. And the second part of that question is, and Eric brought up working with or having discussions with neuroscientists, I was wondering what the status or trends might be in the research of using functional MRI or other brain imaging scanning techniques.
Yeah, I mean, I think every single area we address in the standards could benefit from further research. The task force that I was on, that I chaired, had psychiatrists, psychologists, and judges and lawyers on it, and at every point, we identified issues that could benefit from empirical research. I'll give you a couple of examples. One is the extent to which competence motions are misused. There is some research on this, but there could be much more. I don't think, my perception is they're misused much less often than they used to be. They used to be misused all the time, but now I think attorneys are much better at making motions at the appropriate time. A second is how often judges actually, let's see, how do I want to put this? Do not kowtow to the expert's report. The research shows that judges agree with the expert's reports 95 to 100% of the time. That's one of my concerns behind the ultimate issue is that if experts address the ultimate issue, judges will just read that part of the report and not read the rest of the report. So it'd be interesting to get more empirical information about the extent to which judges properly trained will avoid kowtowing to the report. I think I'll stop there because I think we only have about 3 more minutes left, and I want Eric to
For the second half of the question, particularly about fMRI, that backs us into the whole notion, and you're hearing this term more and more these days, of neurolaw, the final frontier of forensic sciences, anticipated by Freud over 100 years ago, that eventually everything will be reduced to biochemical notions. And also the subject of a popular book, the wildly racist The Klansman, which was turned into that movie, The Birth of a Nation, where the big scene in the book anyway is when they find out who the murderer is by taking a microscope and looking into the eyes of the person to see who it was that actually committed the murder. We've come a long way in terms of a number of things since the early 1900s, but as I suggested in an ABA presentation that we did a few years ago, we're not there yet. And what you find is that as the defense attempts to introduce evidence of certain kind of scans, they find themselves perhaps 1, 2, or 3 skips ahead of Daubert or Dober, depending on how much you're charging, right? You're always, we're not there yet. It's complicated. The scans are not often understood even by the doctors fully, but it's an important area and unquestionably one which requires and is getting a lot of research attention.
If I could say one thing with respect to that, I think it's tempting to say my client's brain looks different than the average brain, therefore incompetent, insane, whatever. And that's just not what the science shows. Again, competence is a functional test. It doesn't really matter what causes it. Well, I shouldn't say it that strongly. But what really matters is whether the person can meet the functional test of Dusky. If you can show they can't, and we got a brain image that seems to verify it, great. The neuroscience corroborates what you're finding in terms of dysfunction. But the important thing is whether or not the person meets the functional Dusky test.
And we're right at 11:15. I think we'd both be glad to take questions from people afterwards, but I do not want to eat up time for our next presenters who are on right now. Thanks very much.
Thank you very much.